We are going to pursue it because we need to hallow the institution which is called the judiciary. We need to send a signal out there that nobody treats the judiciary with contempt. And this is a clear-cut case that no matter how exalted that you think you are still subject to the laws of Ghana, including the President of Ghana. So we are not going to take it lightly.
There are suggestions that you have difficulties because the ones who are supposed to be the applicants, so to speak, are not, they've been repatriated.
The contempt is onto the court.
Right.
So therefore, the individual applicant has no special interest. If you can prove that indeed somebody has defied the express order of the court, it should be heard. And I don't see how a court of law will say that in trying to hallow the name of the court, it is always be, excuse me to say, the accused persons.
So which BNI official are you looking for to be imprisoned on this issue?
Well, I mean, there are about 4 of them, and we hold on for now as we begin to put the papers together.
Interesting. Interesting. What do you want to say about that? That is his case. He says it's going on.
I do not want to commit contempt myself, but I can foresee my brother running into several challenges. First of all, who would the applicants be? Because presently the possible or there would be applicants, in my view, are out of the jurisdiction. You cannot do this. But you know, under the civil procedure rules, if you purport to act on behalf of a person without the clear-cut instructions of the person, you could be in contempt yourself. Here is the case.
Couldn't they do whilst they are out there? Couldn't they appoint attorneys in Ghana if that's necessary?
It's not even necessary.
You know, because of the quasi-criminal nature of contempt applications, my view is that the applicants themselves who are like complainants ought to be present in court.
But you are told that because this is, they don't really need them, anybody at all in Ghana who is privy to what has happened, that the administration of justice has been brought in disrepute, can go and
the Constitution is very clear. It vests the power to commit for contempt in the superior courts.
Correct,
and they do so suo motu. That is, if they are satisfied that a certain action or act amounts to contempt. But here you have a lower court.
But they go to the High Court.
I know. But then it means the courts would have to act on their own. But if you have to come by application, the applicants who are now the subject of
he's telling you that they don't need their home
country.
He's telling you that they don't need
in any case, I'm not preempting in it. I'm only explaining.
What he's saying is that me as a Ghanaian, if I have come to events, I have witnessed events that clearly suggests that the administration of justice has been brought into disrepute. It must not concern me. I should be able to go to the court and say, I have seen this person disobey the orders of the court.
In that case, it would be a function that the state must discharge. The state, not just anybody, the state.
And that is the point. Now, in that case, in an appropriate case, the Attorney General can't commence that action. Because after all, it's Republic versus...
Anyway, we'll be expanding the frontiers of the law.
It's Republic versus so and so. And in appropriate cases, and the Supreme Court has held that it's possible for the Attorney General, like the Atta Kyea case, to even be on the other side against another state institution or public officer. So we will expect that in view of the obvious disobedience that certain individuals have shown to this court order, appropriate processes should be filed, even if not by the individuals, by the state itself, because that is the function of even the president, maintenance and execution of the laws of Ghana.
Thank you.
We have a very strong defense.
Thank you.
Very strong defense.
Thank you. So the experts, as far as the immigration issues are concerned, say